Good morning, dear students. Sorry for the unusual hour, but because unfortunately, yesterday afternoon, when I was giving you a lesson about the United States legal system, the charger of my laptop failed. So, in order to compensate for that unfortunate and unforeseen occurrence, I'm now giving this lesson in a condensed form before the start of today's lessons. So the United States legal system is largely based on the British or originally English common law, which means that the previous court decisions on the civil and especially the criminal cases, the so-called precedents, are largely the basis of the United States legal system, in addition to the constitutional framework. By contrast, and this is one of the major political and administrative differences and judicial differences between the United States and most other Western democracies. Most of the other Western countries that have a democratic political and judicial system use some variations or combinations of the Roman Germanic legal system, where it is much more common to codify these legal changes in the formal laws, which, of course, in the democracies means that they have to be debated and approved by a majority of the participating legislators whose votes are relevant. I word it in this way because there are a number of Western democracies where the upper house of parliament is there mostly as a tradition. Two come readily to mind: Britain and Austria. And also, I assume that in Ireland, the Seanad or Senate doesn't have that much power because it's partly appointed and partly indirectly elected. Okay, now I'll go to the lesson plan and I'll try to condense it reasonably here. Benefit, I'll also then post this video, hopefully later today, with the appropriate link in the stream section of our Google Classroom page. Well, a pedagogical or teaching related icebreaker. What are probably the most commonly heard and remembered phrases of the American police and court TV series, dramas, and movies? Well, the police officers reading to the arrested people their rights. You are under arrest. You have the right to remain silent. Anything you say can and will be used to testify against you. You have the right to an attorney. If you cannot afford one, an attorney will be appointed for you, and so forth. And then, especially in the cross-examination stage, where the defense lawyers examine the prosecution's witnesses and vice versa. In other words, the prosecution lawyers cross-examine the defense witnesses, and always, of course, their intentions are to find logical, legal, and other, even ethical inconsistencies, and, if possible, false and misleading statements in those testimonies. Objection, Your Honor. In other words, when the opposing side's lawyer asks a question which, in the other lawyer's opinion, or even in the opinion of the laws involved, is either illegal or irrelevant or misleading or false, and so forth, then it is typical for the other lawyer to object to that question. Sustained means that the judge accepts the objection. Overruled means that the judge rejects the objection. And then, towards the end of the sentencing hearing, the judge asks the jurors, normally 12, but in some cases 6, "Jury, have you reached a verdict after their deliberation or negotiation? Your Honor, we find the accused guilty of the charges," or "Your Honor, we find the accused innocent of the charges." Of course, if there are 2 or more charges, it's possible for the jurors to reach a verdict where the accused is found guilty of 1 or more of the charges and then innocent of 1 or more of the charges. And of course, the accused, if convicted of 1 or more of the charges, has a right to appeal within a certain period of time, as is the case in the other democratic legal systems. So, to put a long story short, here is a partial summary of the US legal system's basic principles and structures. As I already mentioned at the start of this video lesson, it is based largely on the British or English system of common law. So the multiple decisions of the various courts, local, state, and federal ones, have gradually built up or constructed the actual and practical interpretations and applications of the federal, state, and local laws. By contrast, most other Western democracies have different variations of the Roman Germanic legal system, or combinations of the British American common law and of the Roman Germanic legal system, or systems. And according to the Roman Germanic legal system, usually more legal practices and court decisions have to be inscribed in the actual laws. So what are some of the similarities between the US judicial investigation and trial procedures and those of most other democracies? The other Western ones, Canadian, European, Australian, and New Zealander ones, and the non-Western democratic countries, for example, Japan, South Korea, the Philippines, India, Israel, and then the many native Oceanian, mostly Polynesian and Melanesian countries, and then those countries of Africa and Latin America, which are considered true democracies. The accused are presumed or assumed to be innocent until they are proven guilty beyond a reasonable doubt. In other words, from the viewpoint of this sample rational person who objectively tries to find out what really happened. Then secondly, the accused have the right to an attorney, a defense lawyer. Thirdly, the accused normally have the right to contact their loved ones, at least from time to time during the criminal investigation and or trial procedures. Fourthly, the defense and prosecuting or plaintiff attorneys can examine and cross-examine the defense and state or plaintiff witnesses. Fifthly, the accused can, if he or she is found guilty, appeal the court's decision in the longest case scenario all the way up to the US Supreme Court, which, however, can and often does, in a majority of the cases, does refuse to hear the cases in order to reduce the backlogs of its cases, and in order to also emphasize the federal nature of the US legal system. The US Supreme Court's justices, generally speaking, want to hear only the most significant cases which can have far-reaching legal and or even constitutional consequences as far as the interpretations and applications of the US laws and constitutions or constitution are concerned. But then there are several differences between the US judicial investigation and trial procedures and those of other democracies. First, the US has on average more prisoners than do many or most other democracies, even on a per capita basis, despite the fact that the US population is huge, almost 340 million people currently. Secondly, the US courts, especially state and federal ones, tend to sentence the accused, if they are found guilty, to a literal imprisonment, rather than a suspended sentence, which means a period of probation ranging from some months to some years, during which time the legal officers, especially police officers, will monitor the accused's behavior, and if he or she is found guilty of another crime, then he or she will have to go to jail. Or then sentencing them to community service. This is typical especially for younger offenders and first-time ones, especially if there hasn't been much physical and or property harm involved. In other words, doing unpaid and useful work ranging from a period of tens of hours to hundreds of hours for the community for the purpose of correction. Then the US courts, especially state and federal ones, tend to sentence the accused if they are found guilty of serious crimes such as murder, rape, incest, aggravated assault, aggravated fraud, aggravated robbery, sexual abuse of multiple people, etc., more often to a lengthy imprisonment starting from between 10 and 20 years, including a literal life imprisonment. So there will be no possibility of parole or conditional release. Than are the courts of many or most other democracies, especially in Europe. Furthermore, the US courts, especially the state and federal ones, use the death penalty or capital punishment much more than do the courts of many or most other democracies. After all, the US is the only Western country which has decided to keep the death penalty, and it is in force in over 30 of the 50 US federal states. There are some democracies which use a literal life imprisonment for the most dangerous offenders, such as serial killers and terrorists. Canada, Australia, and New Zealand belong to these ones. There are a few democracies which can extend indefinitely until the accused and convicted criminals die, the life imprisonment. Norway belongs to these ones. And Mr. Anders Behring Breivik, who is a far-right Norwegian anti-Islam terrorist who murdered 77 people in cold blood during one day in July 2011, is serving such a sentence, and it is unlikely that he ever will be released. So the US court system's judicial investigation procedures. Its main goal is to discover if a crime or a similar violation of the law, such as a breach of a contract or an error of ignorance or of negligence, has taken place. Then, to prove who is or who are the likely suspect or suspects in such a criminal case or civil case. Furthermore, to establish the motive or reason for the crime or the smaller violation of the law. Then to gather enough evidence for a possible trial, and then to discover the probable suspects, possible or probable accomplices or partners in crime. And then its major methods to interview or to interrogate or question formally the possible suspect or suspects, their accomplice or accomplices, the plaintiff, accusing party, or the victim, and several or many of the people who have known either the suspect or suspects, the victim, victims, accomplice or accomplices, or any other people or circumstances involved in the civil or criminal case. Then to search the relevant place or places of the crime and the suspects, the victims, and the accomplices' homes in order to discover enough incriminating or exonerating evidence. Exonerating means proving the innocence of the accused person or persons. Incriminating, which is the contrary term, means evidence that proves their guilt, his or her or their guilt. Then to investigate the digital records such as the text messages, emails, Facebook, Twitter, and or YouTube messages, comments, and or videos left by the people who are persons of interest in the case. Furthermore, in the criminal cases, especially the assaults, batteries, and homicides, to examine the corpse or dead body or the body of the victim or victims in order to strengthen, weaken, establish, or demolish the original hypothesis or assumption, working assumption of the suspect's motives for and methods of and the consequences of the crime. And then in the civil cases, to examine, for example, the monetary and or property value or values, spending amount or amounts, income, revenue or profit amounts, and or other forms of money, capital, and or other assets which have been probably involved in the alleged crime or smaller violation of the law. Okay, now, because of the pending lessons, I will have to end this video, but I will continue it hopefully later today. Stay tuned.